Good morning, Mr. Chairman or Mr. Chairperson, distinguished guests, dear friends. Thank you very much, Professor, for your kind words. But I should also say that my department where I work is just a younger brother or younger sister of Poznan Human Rights Center. And of course, there's always been links of friendship between these two institutions. Since 15 minutes is not much, there will be actually more questions than answers in what I'm going to say in a couple of minutes. But of course, I cannot resist the temptation, and I will not resist it, to just say just a couple of sentences in the beginning that I'm very, proud to be here, and I, sort of had to be here. I really still am, let's say, very much, I have, say, image of Lena in front of my eyes, and I also, I think, said it in July, where there was a similar event commemorating her, that it's amazing sometimes how life goes on, and we really miss her. She was a lively, so vivid, cheerful, and promising legal scholar and person that really, it's a loss which will not be easy to replace, of course. And I think I used the phrase "unfinished life" once. That that was really an unfinished life. She had so much to do, but. Of course, I pay tribute to the organizers that they convened this conference. I offered a title suggesting that I will try to evaluate whether the standards of equality are a history of success or not. Well, of course, that hardly can be done, perhaps within this framework, but even if I had more time, then the question is whether you could reasonably and objectively assess the standards of equality in Poland, but be it as it may, I have a couple of remarks which I want to share. I start by saying that, I consider myself human rights scholar and international scholar. I perhaps am not, say, a distinguished specialist on the issues of equality, but when I started to prepare for today, I just asked myself a question, what would you expect and what can you reasonably expect from international law standards as regards the influence on what is at the table when it comes to gender equality in Poland? Since, as we know, fortunately, the issues of equality have been internationalized a long time ago. There are many sources of supranational law which do influence the situation. But now the question is this legal framework adequate? Is it well developed? Can you say that the reception of international standards is satisfactory or not? Well, as always, it depends on perspective. The proof of pudding is in the eating, of course. But now, first of all, we know that there are many standards in this field, starting from international law conventions through declarations adopted within international organizations. Then we do have the, very rich area of EU law, which is also needs to be taken into account. And of course, these standards should be adequately reflected in constitution and in domestic law. Now, are they or are they not? At first glance or first sight, much has been done in terms of transposing, in terms of introducing international standards into Polish law. It's, of course, common knowledge that Poland is a party to the CEDAW Convention on the Elimination of Discrimination Against Women, that I think it's been in 2003 that we also adopted an additional protocol allowing for individual complaints to the CEDAW committee. It's also, of course, not it's obvious that also Poland is part and parcel of international mechanisms which allow for using the legal remedies to bring up certain complaints or remedies. But in this regard, of course, now the question is what is effective in this regard? So the Strasbourg systems with which I'm a bit familiar it shows that, in fact, not many cases about gender equality per se have reached this level, but now the question is it because it's so, so perfect in Poland about gender equality, or is it perhaps for other reasons? I think there is a reason. The reason is that Poland has not ratified Protocol number 12, the European Convention on Human Rights. There's an anti-discrimination clause in the European Convention itself. It's Article 14, but this concerns only the prohibition of discrimination concerning the rights enshrined in the Convention itself. Protocol 12 aimed at enhancing this prohibition. Unfortunately, it hasn't been widely accepted. I think a dozen or so, maybe 15 states have been parties to it. And also this might be considered an obstacle, and that's why not many complaints reached Strasbourg, basing exactly on the issue of gender equality. But you know, of course, perhaps there's no point in listing all the standards. That would be also that would take a lot of time. I would ask something else. I would ask myself, and perhaps also leave that question open. In fact, can we really assume that legal developments and law is well, the best tool, or is it really the principal way of improving the situation? Well, to put it in different words, isn't it so that, in fact, we have enough guarantees? We have certain, you know, rich table of various standards and conventions, but it's not, maybe it's not law which is a problem when it comes to gender equality. Well, perhaps lawyers did their job already. You know? I think it's too serious to leave it just for lawyers, of course, because they usually just, you know, tend to complicate things. I was just wondering, is it really so that we need more standards, we need more strict standards, or is it rather that we need to focus more on some social patterns, social stereotypes, to just simply you know, be more straightforward about it? And you know, I just sometimes think we live in a world where we consider that law will just make the world perfect. It's not true, really. But on the other hand, there are scopes for improvement for sure. Some new developments, new legal developments are there. I think that, well, later on this conference we will have the chance also to discuss, for instance, about quota systems. It's relatively recent development in Poland. Now, you can discuss whether it is enough or not that 35% of places on electoral lists should be reserved for one or the other gender. But you know, this is a development. Now, it's a matter, I think, also of political assessment. Is it enough or not? Or 50% would be better. But is it really about law? Is it really about percents? Is it not perhaps a better way to really, you know, find ways to encourage participation in public life for both genders? Anyway, I believe that simply what I'm saying is that apart from focusing on law and legal provisions, I would really see some scope for improvement on the just scene for social patterns. But now also there is another question, and notably, are these standards adequately reflected in Polish law? Well, there's Article 33 of the Constitution, which I think should be considered well, mainframe, a pillar of the system. There is a relatively recent law about implementing certain EU provisions in the field of equal treatment. Is a 2010 law, which is a bit disappointing as well, of course, which has been sort of forced out by the European Union, since Poland was facing some penalties even, or simply had to introduce this law. It's disappointing in many ways because it has a lot of exceptions, and I believe that, well, it's better than nothing, but still not enough, of course, in this sphere. And, you know, just to, well, put it all together, I believe that we should not complain that much about legal standards in Poland. It's rather the political choices that we could complain about. And sometimes, of course, I know that political choices then influence legal solutions. But on the other hand, I don't think that law and lawyers themselves have such power, really, to change also as well certain stereotypes in the society. I think that's just everybody's job to do so. Let me provide you with a certain example, also quite recent, that, you know, you can have very recent laws, very modern, up-to-date standards, but at the end of the day, you just have something on your table that just shakes the perfect image. We do have in Poland a definition of a young scholar and young scientist. It's important because, up to a certain age, scholars in Poland can apply for certain types of funding, just have certain ways of funding their research and so on. And there's a 2010 law on the principles of financing the science, which provides for a definition. It's a very simple criterion. Just a person needs to be a scholar and needs to be under 35. Well, of course, feeling a young scholar is subjective, because you can be much older and feel young, of course, or vice versa. But in fact, it's an example which is, I would say, close to my heart, since it was last year that my two very good colleagues from the Institute of Philosophy at Nicolaus Copernicus University approached me, and they launched gender studies program in Torun, and I'm proud to be invited also to contribute. And she just told me, we do have certain difficulties, since, some of us, of course, would like to benefit from being a young scholar, or just approaching or just past the age, this magical threshold which the lawmakers set. But tell us, what do you think? Is it really just, and is it okay with your international standards that some of us just take maternity leaves, some of us take childcare leaves? By the way, nowadays, this year, I think it's the kind of breakthrough, since the maternity leave will be much longer, or can be much longer than previously. So they asked me, tell us, is it okay that some of us spend long months on leaves and take care of our children, which is of course obvious and natural, but on the other hand, this is a period in our lives which of course is off. It's just taken out from our professional development. So where do you have the gender equality here? Whereas that may also concern men, of course, though paternity leaves in Poland are much shorter and much less common. I think still there's a lot to be done about it. So this is a real case about gender equality, is it not? So simply speaking, how can you claim that you have equal chances, that you have equal status and gender equality, whereas our female colleagues, female doctors who just spend 6 months or a year or longer just taking care of their children are, then focused on utterly something else, and when they reach this threshold, they cease to be young scholars in the eyes of the lawmakers. So, actually, this story has a follow-up, since the Faculty Council of the Humanistics in Nicolaus Copernicus University just, debated along about it. Since my female colleagues there are really, progressive, and I'm happy that they pushed that matter forward. So that council addressed, I think, the ombudsman with that issue, and I am also very much, positive about it. I have here a copy of a letter from the ombudsman office, which I think is going to be just one step forwards. I think the relevant authorities were informed about the matter, and this is really reassuring that there are mechanisms about which allow us to react. Of course, in institutional terms, it's also the office of the. In institutional terms, it's also quite a recent development that we have the government plenipotentiary for equal status. So there is some light in the tunnel, I would say. Much is to be done, but again, let me at the end to underline my principal reflection here. It's really not only about law. It's really not only about just multiplying legal standards. I think it's more about influencing social patterns in other way. So I will stop here. Thank you very much.
Thank you.